Well, thank you so much, Johlene, for joining us and agreeing to co-host this webinar with us. We really value your input to into the community schemes education that you're doing, and we really look forward to educating our participants on this webinar today. So thank you so much for joining us. As we are about to go into this webinar, again, our presentation today is on alternative steps in dealing with non-paying owners. So I'm sure this is seems to be a very hot topic. We've got a lot of participants on this webinar today. So it seems that a lot of people want to understand this and know how to go through CSOS and what alternative steps they can take for their non-paying owners. So in our webinar today, we will be giving out some free resources. We'll be sending an email after the webinar with a link to this recording, as well as a link to our free resources. Plus, all of our existing free resources that we have given previously can be found on our website, which is www.stratafin.co.za. So go have a look there, and there's tons of free resources that you can look at there. So on to our speakers for today. So we've got Willie Roos, who is the CEO of Stratafin. Willie has practiced as a property attorney for over 20 years. He has been involved in sectional title management for over 8 years. Willie started Stratafin in 2014 with the goal of assisting bodies corporate with their funding without catching them in a debt trap. Stratafin strives to be a fair and equitable money provider for the sectional title industry. And Willie has built up Stratafin from inception to today, where it has debtors under management of over 300 million rand. Stratafin has also partnered with Medu Capital, and the PIC has invested with a 45% ownership. On to Johlene. I don't even think we can fit all the things that Johlene has done onto one page. When I was looking at this, I was shocked at what you've done and what you've accomplished in your life. So Johlene Wasserman, welcome. She is the Executive of Governance, Compliance, Enforcement and Training at CSOS. Johlene has been with CSOS since its inception in 2015. She has worked as a conciliator, office manager, regional complaints manager, governance, compliance and enforcement manager, and is now the acting executive of governance, compliance, enforcement and training with CSOS. Johlene is an experienced governance, compliance and enforcement specialist. She is an accredited mediator, an admitted attorney and a conveyancer, and she holds an LLB and an LLM with 15 years PQE proven expertise in property and real estate law, with alternative dispute resolution, governance, enforcement and compliance, as well as mediation, customer complaints, resolution, litigation and contract management, King 4 and corporate best practice. Johlene, is there anything you haven't done yet? Okay, great. So let's go on to our presentation. And Johlene, I'm going to hand over to you to continue this. So thank you so much.
Can I just say one thing as well? Sorry, Johlene. I'm going to jump in every now and again and ask a couple of questions during the process, which you can then explain to us a bit more in detail, if you don't mind, Johlene, so that the questions that have come up already can be answered during the process.
Of course, thank you for that, Willie. Am I going to share on my side, or is this do I have access to the presentation to control it,
So Johlene, what I will do, I will handle the presentation from my side. You can just chat, and as you go through, I will just continue to share the screen and go through, flip the pages. So please continue.
Thank you so much, Daniela, and thank you for the opportunity, Daniela and Willie, to be a part of Stratafin's webinar today, and of course all your members and your clients. We value it as CSOS. We would like to be out there in the industry, and we would like to be as visible as possible and to engage with you, our very important stakeholders. So without further ado, I will start. Please interrupt me, Willie, as I go along. We welcome it, I welcome it, and let me start. So the dispute resolution process at CSOS, this is the first process that we established at the CSOS in 2015. Even before our act was promulgated, we felt that conciliation is key because it's parties sitting around a table, and we as conciliators facilitate the process, and we give legislative advice as to what needs to be done. So conciliation is extremely important at the CSOS. We would like all matters to be first conciliated and settled, and very little goes through then to adjudication. So the process has been tried and tested, and we are still improving and streamlining the processes to make it as easy as possible for you, our clients, of course. So there's a dispute resolution form. Everything starts with this form. This form can be filled in online on our website. Fill in the form and it goes straight through to the specific province, be it Free State, KZN, Gauteng. It goes straight through to the province of where the community scheme is at. That office receives it. They then look at the form to ensure that everything is on there. And remember, you cannot just fill in the dispute resolution form. You must attach certain documents to it in order to prove your case. We here at the CSOS are neutral. We only enforce the legislation at the end of the day. So what you allege, you have to prove at the CSOS. If you are, for instance, referring to a meeting that was held and you are not satisfied, or you feel that the meeting was null and void, you have to attach the minutes of the meeting if you're in possession of it, or the agenda, or give us anything to substantiate your allegations against the community scheme. So what are we looking for? A copy of the scheme governance documentation, that's the rules or the MOI or anything pertaining to that. A copy of the sectional title plan, or copy of the homeowners association plan, a copy of the title deed. This can be obtained from the deeds registry. Anything relevant to your dispute, a copy of the meeting, the minutes of the meeting, photographs if it's private and common areas, if there's a leak, audited financials if you allege there was any misrepresentation or misappropriation of funds, a copy of the summons, because many people still come to the CSOS if they have been sued by their community scheme for being in arrear with contributions. We need for you to attach that summons, because needless to say, the CSOS cannot proceed with that matter if the matter has not been withdrawn in a court of law then. And a copy of the administration order, of course, if you allege the administrator has been appointed, however, you have not been receiving quarterly reports, then the CSOS can assist with it. It's not necessarily a dispute. It falls within the governance unit. But if you attach these documents, we can see where this matter can go to. So it's very important to attach your supporting documents. The CSOS will then go through everything. You will receive a reference number. And this is now where the process begins. We either accept your matter, the ombuds will do in the provinces, or they will reject your matter. If your matter is accepted, you will ask to be paid a fee, 50 Rand. However, please take note, members and clients of the CSOS, that you do not have to pay the CSOS fee if the CSOS has waived your CSOS levies as well as your CSOS dispute resolution fee. There's a practice directive for waiver. We please encourage you to apply for that waiver if you do qualify for it. No applications, unfortunately, can be made anonymously here at the CSOS. You have to state your name and what your complaint is about and whom it is against, because obviously we as the Ombudsman are neutral. We have to give that respondent the same opportunity to respond to your allegations. That respondent is given 10 days to inspect your application. That is what we call a Section 43 notice we send to the respondent. Say, respondent, here's the allegations against you, 1, 2, and 3. You please respond. Thereafter, the case management officers will formulate a case, they will build the file, and they will hand it over to the conciliator. There is very little instances where it goes straight to adjudication. We want that conciliation process to go ahead for the parties to sit around the table or the virtual table nowadays, unfortunately, due to the COVID-19 pandemic, and to say, parties, please resolve this. CSOS will be the conciliator and facilitate the meeting. Parties are given a 14 days calendar notice of the conciliation, and it can be informal, quick telephone discussion. It does not happen often, I have to admit, that the CSOS, because parties would like to be heard around a table, and now via Teams or Zoom. And then the formal type that I just discussed. All parties to the conciliation will be chaired, as I said, by the CSOS. The conciliator will assist in facilitating, find a resolution, and if the matter is not resolved, the conciliator unfortunately needs certain issues of non-resolution, and then it will be sent to the adjudicator. Now, with adjudication, it is very important to note that once that matter is at the adjudication, and even more so now with the pandemic COVID-19, that adjudicator is going to assess the outcome on the merits and on the papers before him or her, because we do not have face-to-face conciliations or adjudications currently. However, adjudicator might contact you to give evidence, photo evidence, statements, additional information, anything like that. That's what we call the investigative period. Adjudicator has investigative powers, so they send out a compliance investigator to investigate this. Then when the adjudicator has all the documents and him or her is satisfied that they can make an outcome, they will issue an adjudication order with an outcome. Unfortunately, there's always a winning and a losing party with adjudication.
Can I ask a question here? I've asked you this question in a virtual meeting that you and I have had before. We as lawyers know that courts and people that are sitting to hear matters sometimes get matters wrong. And from a perspective that I've practiced law for many years, I've seen that matters get a judgment gets there's a wrong judgment in respect of facts or of law. Are these matters on law and on fact appealable once an adjudication order has been made, or what is the situation regarding that?
Thank you, Willie. Very important question. So at currently, as we speak, with our current legislation that's been drafted in 2011, unfortunately, there's no internal dispute, internal appeal mechanism. You'll have to appeal through the high courts in South Africa, because only they can hear an appeal, and it is very expensive. And we have been amicus curiae, that means friends of the court, a couple of years ago, where the judge delivered judgment, and he said that they can only discuss it on a question of law, whether the adjudicator was right or wrong in their findings. So they're going to basically look at whether the adjudicator applied the law correctly. However, I'm not sure if you know, and if your clients know, that we are currently amending the legislation to have an appeal process internally, because it is very costly to go on an appeal, and that defeats the entire purpose of the CSOS, to say, well, here's the adjudication order, we made an error of law, please go and appeal it, spend 100,000. It's just not financially viable. So we would like to have an internal appeal mechanism process prior to the parties going to the High Court.
Fantastic. And will that also apply in respect then of mistakes that were made in fact?
Yeah, we have a practice directive currently which states that an adjudication by there's 4 things that can have an adjudication order amended. That's but it's non-material. It's like a spelling error or omission, or if the respondent did not receive the notice. However, on a fact of law, yes, we will definitely have an internal appeal mechanism before parties can go to the High Court. Yes.
That's fantastic news to hear that that process will be put into place.
And just to add to that, Willie, of course, we will have public participation, as all amending legislation will have. We almost finalized the amendments on our side. We have received various inputs from the industry, whereafter we're going to take it back to the industry before we table it at the Portfolio Committee in Parliament.
Right.
Right, so we've discussed the adjudication. Now, if adjudication order, all parties will receive the adjudication order within 14 days. That is in terms of our legislation. An order cannot be received after 14 days. It must be received by the parties within 14 days. This is also our commitment to you, our stakeholders, to say we would want to enhance our services and our efficiency and our turnaround times to you. So what do you then need to take this adjudication order further? You have the adjudication order, you are the winning party, and we promise you that the majority of our adjudication orders are enforceable through the High Court. So what do you need for it to be enforceable in the High Court? You need a copy of the adjudication order certified by the Ombud as a true copy. You need an enforcement notice. It's a sheet which the clerk of the court or the registrar would need in order to open a case file and to give you a case number. It is then stamped by the High Court, and this then means that you have an enforceable High Court order that you then take to the sheriff. Unfortunately, the CSOS process stops when that registrar or clerk of the court has issued the case number. It is then up to the winning party to take the matter to the sheriff for the warrant of execution process. It's a similar process. It's the same process, in fact, as what is happening in the courts of law when you execute. And then the sheriff will, of course, go to the respondent's house and writes up the goods in order to sell those goods, perhaps in order to realize the monies for this order. In terms, I can mention one, it's a contribution for arrear levies. Johlene has not been paying her levies, and the sheriff comes to my house and would like to write up my stuff and sell my stuff in order for that levy debt to be covered. However, we are aware of there's many nulla bona returns, which says Johlene doesn't have any property to execute in order to pay for her levy debts. We do have that in mind when we are drafting the amendment of our legislation.
So what you are saying is when that amendment is coming through, we're going to see that this whole process that now continues to play out in the High Court or the Magistrates Court will then be able to be played out through CSOS. So what we are currently seeing as the Rule 46 process in the High Court, where you then go and explain to the court why a court should allow the sale of immovable property to take place and why it is not against somebody's constitutional right in terms of Section 26 of the Constitution, and why it is necessary for the body corporate to be reimbursed these outstanding levies. That whole process will then take place through the CSOS procedure as well.
Yeah, that's what we're aiming for. We want to call it cease and assist as well. You know, many other state-owned entities or public 3A entities has that in their legislation. It's worked well for them. So we would like to bring that into the CSOS legislation, because we do understand that the real costs start when that case has been opened and you received your case number at the High Court, and then the cost starts for the execution process, and that once again would defeat the purpose of the CSOS being efficient, cost effective, and more speedily than the court. So yes, that is what we are currently looking at.
Yeah, absolutely. I mean, if I can just continue on the conversation that we had a couple of weeks ago regarding this, where I said to you that about 80% of your cost actually accumulates after this first order by CSOS or the default judgment. So that would be a fantastic process where body corporates then, or bodies corporate won't then have to spend further money to actually collect those outstanding levies, because we understand that once people are not paying levies, that whole scheme collapses and everybody's investment in that property, the investment falls apart, and they can't sell their properties and they can't get the price that they want to get as a result of non-payment of levies. So it's important that levies are paid, and it's important that it can be collected in a cost-effective manner like you guys are now wanting to put in place. I would just think there's going to be a need of lots of people in respect of that. So yeah, I think CSOS is going to grow exponentially.
Definitely, and we are daily, new faces daily. We started off being 10. I think we're over 150 employees now at the CSOS. So most definitely, we grow as the needs grow. Definitely, and there's something we have to look out for. So that is the dispute resolution process. If you have any questions, anything on it, you're welcome to contact the CSOS officers or myself, of course. I'm sure you have my email address and my contact details, and of course you can also touch base with Stratafin that knows the process very well. Then there is two ways.
Sorry to interrupt. I just wanted to say on that point, we will be sharing via email your contact details after the webinar. Plus, at the end of this presentation, we will show your contact details, so everyone will be able to contact you. We've got a question here. Does the applicant have to be a trustee in the case of the levy arrears, or can they appoint a representative, being their managing agent or an attorney?
Yes, of course. They can appoint a representative, a managing agent, or an attorney. Of course, we find often it says managing agent A on behalf of trustees are bringing this application. Yes, of course. You'll just need a power of attorney, or you'll just need to say that the managing agent is here in representing the board of trustees of so-and-so scheme to bring Johlene to the CSOS for arrear contributions.
Thank you.
Thanks, Johlene.
Must I proceed?
You can.
Thank you. So there is actually various ways to ensure a constant levy stream and income in your community scheme. And by law, we all have to pay levies. No one is absolved from paying levies. The CSOS waiver is not even going as far as scheme levies. Everyone must pay a levy. It is law. Without that levy, it's detrimental to community schemes. And as we know, it often ends in a disastrous effect for everyone, because I can't sell my unit. I don't want to buy into the scheme. We can't maintain. I don't need to tell all of you why it is so important to have a levy income in a community scheme. So what to do if I simply refuse to pay my levies? Well, the first one is what we call the rental attachment orders. It is in terms of section 39(1) of the CSOS Act. That's how important we deem levies, as it is number one in the disputes that you can bring to the CSOS. And it's also 80% of the CSOS dispute resolution book is arrear contributions. We do understand it's difficult times. However, unfortunately, the Act cannot allow for you not to pay your levies or to short pay your levies. So what do? Take myself, for instance. Johlene owns a unit. However, I have a tenant in my unit. And it just so happens that the body corporate knows everything about this tenant, because in the conduct rules, or in the as the information officer in terms of the POPI Act, the trustees would have a big database of all the information of both owner and tenant in terms of the Information Regulators POPIA Act. So Johlene is a tenant. You extract those information from your database. You fill in the application form for disputes. You say the tenant is Daniela. Johlene is not paying her levies. We would like the tenant to directly pay the rental into the body corporate's account. It must be, however, it's very important to note that the tenant must be cited as a co-respondent. So you're going to cite me, and then Daniela as the second, as the co-respondent. You then ask for the prayers of relief. Please let the tenant pay the entire rental into the body corporate every month until such time as the member's arrear account is settled. The tenant must not offset any amount or deduct any amount from the rental amount if there's any counterclaim the tenant might have against the landlord. So Daniela can't be aggrieved, because now she's worried. She's paying her rental every month over to me, but I'm not paying the levies. So nothing like that. The entire rental amount must be paid into the body corporate account. What does this mean for the tenant? The tenant now has a legal duty to pay the rental amount over to the body corporate and not the landlord. The tenant is discharged from his or her liability to pay rent to the landlord as per the lease agreement. Very important. The landlord cannot now take you to the rental housing tribunal, say, not paying the rental. Here is an adjudication order stating that the tenant must pay it into the body corporate's account. Now, the question we often get asked, must the tenant now continue to pay even though the arrear amount has been settled? No. It only if there's 100 Rand owing, the tenant only pays until that 100 Rand has been paid. The body corporate will again lodge a dispute with the CSOS if the member again fall into arrears. The tenant only pays the rental into the body corporate until such time as with the arrears are settled. And that is all about rental attachment orders. I'm just going to pause.
There's a couple of questions regarding that. In most bond documents, it says that the rental income is ceded to the bank in respect of the payment of the bond. And would the CSOS order rank above that agreement that was entered into between the owner of the property and the bank that now actually has the right? Would you have to bring the bank in as a party to that application as well, or how would that be handled?
Yeah, you see, that's a difficult one, because if there is an agreement such as that, CSOS has no jurisdiction over a bank. You know, we cannot add them as a party to the dispute. I really have to think about this one. I've not seen it in our dispute forms that there was an overlapping of this. However, can I get back?
Sure, definitely. I mean, that's a very valid, very good question. Yes, I mean, because all bonds, I mean, you would know as a conveyancer, I mean, we've registered hundreds of bonds, and you would know that all of them state that the rental income is ceded to the bank to ensure payment of the bond. So if the owner does not pay his bond, then the bank is entitled to actually go get the rental directly from the tenant to make sure that the bond is paid.
Definitely. No, that's
a fantastic question.
Yeah, no, definitely. Willie, what I'm going to do, I'm going to pose the question, and I'm going to give the answer, and I'm going to send it to yourselves, if you wouldn't mind sending it then to your members, so we have it in writing. Good, it's a very good question, and it must be addressed going forward. Thank you very much for that.
And one other question that came up while we were talking here was also, if the rental payment is made via an agency, do you then see that estate agency also as a party, or do you just go to the tenant itself?
Yeah, we often have that because many landlords rent out their properties through rental agencies. So we do not, they don't need to cite the rental agents. However, mention is made that the tenant must now pay the rental straight to the rental agency, and the rental agency must pay it straight into the body corporate's account. That often happens, yes, at the CSOS.
Okay, thank you. You can continue, Johlene.
Thank you. So we covered rental attachment orders and now disconnection orders. So we as the CSOS, if a member is in arrears with their levies, as you know, it is an urgent application at the CSOS to immediately restore the water and electricity supply if it has been disconnected by the trustees. However, there is recourse, trustees and members here today, if a member is not paying their levies. The electricity can be disconnected. However, it cannot be disconnected by the CSOS, and I'm going to tell you how it can be disconnected and where the CSOS lacks jurisdiction in this regard. And remember, it is under section 39(7)(b), and it's any other order proposed by the Chief Ombudsman. Now, this is this is actually the only relief that falls under Section 39(7)(b) is the disconnection of electricity and water and to restore it. There's no other orders that is made under 39(7)(b). We are currently busy with the amendment of legislation, as I said, in order to give more clarity, because it's not very clear if it only says any other order. So please just keep that in mind. We are working on that.
Can I be mischievous here a bit? I think in the email this morning when we were chatting, I said that again, and I said, is it not possible that under 39(7)(b) that a order can be granted to the body corporate as a stick to an owner that is not paying, that says, well, until such a time as you paid, we're going to disconnect the electricity? Because I mean, people learn when there's consequences. So should the chief ombudsman not make an order, or should it not be in the practice manual then that says under these circumstances, it will be CSOS will be entitled to grant an order, like the courts can similarly grant to disconnect electricity until such a time as payment has been made of the arrear levies?
Definitely, you know, as it stands now, we wouldn't allow it, and we reconnect. We instruct for it to be restored. However, yes, it's what we're looking at going forward. So that is a valid point. Thank you for that, Willie.
Okay.
So yes, it's an urgent matter, as I said. We will then immediately restore the electricity and water supply within 48 hours. So what I would like to advise is trustees, members of community schemes, please do not disconnect water and electricity. You have another recourse that you can follow. However, you cannot disconnect it, because when it comes to the CSOS, we will just automatically instruct you to pay the reconnection fees and to reconnect. So can I legally disconnect electricity without a court order? Yes and no. No, if you are a body corporate and instructs the security guard, the agent, the caretaker, or trustees to disconnect without an order, you're not allowed to do that. Yes, you can disconnect without a court order if the third party is a reseller of water and electricity and in affiliation with the municipality, and they must adhere to the bylaws. So yes, you can disconnect without a court order, and that's what I want to discuss today here. Once again, I would just like to reiterate, the CSOS does not have the jurisdiction when a member or tenant's water or electricity is disconnected or reduced by a meter company who is a reseller of water and electricity, not the body corporate. The meter company can disconnect your water and electricity if you are in arrears with your levies. They don't have to have a court order. They must be a member and a reseller registered with IRASA. Irrespective of that, the company is cited as respondent or not, irrespective of whether the member or tenant signed the agreement. Now, we often find, say for instance, company A is a meter reading company, but Johlene is the member. I refuse to sign an agreement with meter reading company A. It's irrespective, they can still disconnect my water and electricity, even if I refuse to sign that agreement with them. So why can this meter reading companies, and how does it work, and what can they do? So, for instance, they bill the body corporate and say, you've consumed so much water or electricity. They receive the money, so we pay it into their account. They pay over the contributions to the local authority, be it the municipality. So the CSOS rejects these applications if we receive it and say, but the meter reading company has disconnected. We reject it based on the following. Section 1 of the CSOS Act defines a dispute as follows. It means a dispute regards with the administration between a community scheme and a member who has a material interest in that scheme. When the applicant cites the third party as the respondent, the meter reading company has no material interest in the scheme in which the applicant lives, and the CSOS has no jurisdiction to hear this dispute or make a finding on it. In other words, and by way of explanation to the applicants, if the adjudicator were to make an order, it would simply not be enforceable in any court.
Johlene, so what is the situation where the body corporate becomes a reseller of electricity, and then stand in that contractual relationship with the city of Joburg or Pretoria, and as such is as the scheme responsible as the bulk supplier of electricity, then surely those owners are now in a contractual relationship with the body corporate, and it's no longer on the basis of the fact that they are members of the scheme, but it's in connection with the contractual relationship between the parties. Or am I wrong in this regard?
Yeah, I think body corporates cannot be seen as a company that is registered with the CIPC and then provides meter reading services to themselves. It must be a company, they must be part of IRASA, they must be registered at the CIPC, and body corporates in itself is not. They're registered at the deeds office. So no, we've not seen applications where the body corporate is selling these services to the body corporate. It is merely companies that is the supplier of these bulk services.
So I have seen many body corporates that have now registered under this legislation, where they have gone out and they've registered and they are now seen as the reseller, and they are sitting then in a contractual relationship with every owner to supply electricity on the basis that you need to pay for your electricity, otherwise we cut the electricity feed.
Yeah, as in my opinion, as it stands, they will have to obtain a court order. They can't do it because, remember, they will not fall within the provisions of the bylaws of the local authorities then, but they always have the avenue going to a court of law and getting that court order against that defaulting owner, and we welcome it.
Yeah. Okay.
Okay.
Perfect.
So what legislation are we looking at? And I specifically took the city of Tshwane. Section 20 pertains to the electricity supply bylaws. And how does it work? Well, the meter reading company enters into agreement with the city of Tshwane as the bulk consumer of electricity and water at the body corpus premises, and then the impact therefore becomes responsible for monthly payment of the bulk supply account to the council. In turn, the meter reading company enters into an agreement with individual tenants and bills the tenants. Now, remember, if you don't want to sign that agreement, they can in any event still disconnect. The meter reading company pays the bulk supply account to the council on a monthly basis and essentially becomes the electricity supplier to the consumer within the premises. And that's how it works. So there is various provisions for it. If you look at clause 4.1 of the city of Tshwane's standard the electricity supply bylaws, it says that if a person uses electricity supply without entering into an agreement with the municipality, the supply must be disconnected immediately, and the person is liable for the cost of electricity used as provided for in section 18. So it is covered. They are fully legitimate to disconnect services if they are a meter reading company. And just to advise that IRASA is the Electricity Resellers Association of South Africa. So, and of course, and this is in terms of NERSA, that is the National Energy Regulator of South Africa and their act. So members, please note that electricity, water can be disconnected in two ways. This can be by the third party, or the body corporate must approach, and an HOA must approach a court of law if there is a bulk water meter or bulk electricity and the members not paying their levies. They will disconnect the.
And I just add here, they can also not reduce this. I mean, we're saying disconnect. Reducing is also illegal if you don't have a court order, because I see that was one of the questions that was asked. So even that is illegal unless you have the court order.
No, definitely so. Thank you for that, Willie. Also, no reduce or tampering with it. So definitely so. So yes, that is it, and that is what we would like to advise as CSOS here today. Thank you very much, and I'll hand over back to you, Daniela and Willie. Thank you.
Thank you, Johlene. I see there are a couple of questions here, and we do have a bit of time, so maybe we should just go through the questions and you can answer them.
So one of the ones that, sorry, Daniela, one of the ones that I've seen was spoliation. So obviously, if the body corporate does disconnect or reduce the feed of electricity or water, that is spoliation in our law, and an application can be brought in the Magistrates Court or in the High Court to have that, and at CSOS to have the feed reconnected. And that cost will be for the body corporate, and one must be, as a trustee, very mindful of the fact that you stand in a fiduciary duty towards the body corporate. And if you make a decision like that, where you know that it is not legal to do so, you are exceeding the powers that you have, and you are not acting in accordance with your fiduciary duty. So the body corporate might turn back to you and say, well, you must pay that cost in your personal capacity. So it is a very, very dangerous game for a body corporate to play. So it's important that the right mechanisms are followed when one does disconnect electricity or water, or reduce water feed, or whatever the situation might be, that you do it in terms of a court order. And hopefully at some stage CSOS will understand that that is a mechanism that one can utilize to make sure that owners pay, because there are delinquent owners that never pay. We saw there are body corporates with thousands and thousands, hundreds of thousands of rands outstanding. And I mean, we deal with it on a daily basis. We have levies exceeding the value of units, and it is a valuable tool to make sure that those people start paying again. So yeah, so guys, be careful as trustees not to do that. Get the court order, get the order from CSOS in respect of what you need to do. Don't take the law into your own hands.
Great.
I think, if I may add there, Willie, it's also important that if parties would like to approach a court in terms of disconnection of water and electricity and not sure how to go about it, the CSOS has got many case law of judgments, how it's been done, what needs to be done in order not to bring an application perhaps with that you have no experience in, or your attorney might not have experience in. So if there's any case law that the members would like, we can send that on to them, of course, and to see how it works. We have one for the reduction of water and electricity, disconnection, etc. So we can assist with that in order to ensure that you get that order the first time around.
Fantastic. Then I also see that they're asking about the cost of the enforcement order after the CSOS, after CSOS gave the enforcement order. And I think I did say it earlier on, the majority of cost actually lies in the collection process after the enforcement order. But luckily CSOS understands that, and they are working towards amending that process so that they can deal with it in-house. So it's important that we all work with CSOS and assist them so that we can get this sorted out, that it is done in such a way that it does not affect schemes negatively, because we all know that levies are the lifeblood of body corporates, and if there's no levies, those schemes become dysfunctional, and people's money, hard-earned money that sits in those schemes, are then wasted as a result of people not paying levies. So it's important that people understand that they have an obligation to pay levies, and that the process be done in such a cost-effective manner as possible, so that it doesn't place the further burden on the paying owners to pay those costs.
Definitely so, I agree with that. And the CSOS, let me just add there, Willie, the CSOS will not make an order that you are absolved from paying levies. We often find that whether it's the development stage or whether I'm an owner and I made an arrangement with the body corporate, I provide maintenance and I don't have to pay levies, there's no such thing. CSOS will never make an order to that effect. Everybody should pay their levies accordingly, it's law, and we endorse that. And however, when it gets to adjudication, we might want just to look at if there's a payment plan, if the respondent wants to enter into that. However, the body corporate is under no obligation to enter into a payment plan with the defaulting member.
And on that basis, there is a question that says, does the body corporate have to take owners in arrears to CSOS? Can they not draft a settlement agreement without CSOS entering into that agreement? And asking because concerned trustees may take these matters into their own hands and not treating all arrear defaulters equally. And I think on a previous webinar, we said it is important for a board of trustees and a body corporate to actually adopt a credit policy, that they understand how they're going to deal with it once that happens, so that people are treated equally. And Daniela said the free resources are available on our website, and we have a draft credit policy that we've made available that bodies corporate can change to fit their purpose and decide this is how we want to treat it in our scheme. So that people are treated equally, because it's important that you treat everybody in the same manner, not one person, because I know the chairman is going to pay off over 12 years and the other one must pay over 3 months. Otherwise, we're going to proceed with legal action against you. I mean, we need to treat people equally.
No, definitely. And just to add on to that, there is no legal obligation for any member of a community scheme or any executive or director or trustee to bring matters to the CSOS. You have the avenue of settling it internally, or of course you can go to a court of law. So there is no, we are not forcing you to come to the CSOS. However, we welcome if these matters are settled internally and a settlement is drafted, and then provided that the member abides by the settlement agreement at the end of the day.
Absolutely.
So
Can I ask you a question which is unrelated to our discussion today, and it's just Poppy related, and we've had this and we've had these discussions, many of them, because it's all happening at the moment. So I think it's the all happening thing. We were discussing who's going to be the information officer. Must it be the chairman? Is it the whole board of trustees? Do we have clarity on that as yet, or don't we still have clarity?
Yes, well, no fault of the CSOS, I might add on that one. We are going to have an audience within the next week with the information regulator, the CEO. I spoke to him. They overlooked the CSOS when they had their webinar, and they never sent us the link. So we couldn't comment on that. Yes, we are bringing this matter up with the information regulator in the next week. We will provide feedback. We would like to reiterate to the information regulator that as a regulator ourselves, if a person or trustees or directors want to employ a managing agent as the information officer, then they have the right to do so. As currently stand, it's only a chairperson, a estate manager, or a trustee, or a director that can be an information officer. And this really limits the individuals who can be one. As you know, all the managing agents have the database in any event. So, you know, for an additional fee, we leave that up to, of course, the managing agents and their clients. They can be the information officer. But yes, Willie, we will get back to you. We are really pushing the information regulator for a meeting within the next week, and we will discuss this then.
And then the follow-up on that, there's a registration process that needs to take place by the 1st of July. Has that now been postponed? Is there a grace period again for
yes.
schemes?
I do believe there is a grace period. I took under correction. I think it's extended for a 6 months period. So we're also going to touch on that to provide clarity, especially within the property industry. Yes. You know, because, I mean, we're talking about hundreds of thousands of schemes. So, yes, that's definitely also on the agenda with the information regulator.
Thank you so much for that. Daniela, any other questions that you pick up here
the questions are coming in thick and fast at the moment. I don't think we'll be able to get through everything that's come in. So perhaps, Johlene, if you wouldn't mind, if I just pop you an email with all these questions, and we can just provide responses, which will then also be put into the email that we send out to everyone who registered. I think that'll be very helpful.
Yeah, thanks. We do a lot of these webinars, and we have a document with a list of questions. I think it might overlap, so please send me the questions. If it overlaps, I'm in any event going to send you that set of it's 2 documents with questions and answers, and then of course just add on to this, and I'll also add on the question about seeding the rental income then to a financial institution, which I think is a brilliant question.
And then I just see something else which has become a problem in respect of the information officer, and that was in the regulator's site. The same person could not register on their website for more than one scheme. So if you're the chairman in one scheme and you're also the chairman in another scheme, you were not allowed to register for more than one scheme. So maybe that's also something that CSOS maybe can take up on behalf of the members.
Yeah, also on the agenda.
Perfect. Yeah. We really appreciate all the help that you guys are giving us, and the training and so forth. It's awesome.
Of course, anytime. We have made 11 YouTube videos on Monday. We are releasing them within the next week or so. We're writing articles. Remember, it's not just sectional title, homeowners, life rights, housing cooperatives, share blocks. We have a template MOI if companies are struggling to formulate their memoranda for incorporation. So the CSOS can provide you this, and all our training is of course free of charge. Thank you.
Fantastic. We really appreciate your time. We know that you're a very busy lady. Thank you so much.
Thank you.
Thanks, guys.
Thank you. Thank you, Johlene.
One last thing before we run away. Just want to tell you guys a bit about Stratafin. Stratafin assists community schemes with funding solutions. Our solution is completely different from what you guys have seen out there. We do have a loan, but that is not our main product. Our main product is the purchase of a real levy. So we then purchase that from the body corporate at an agreed price. And we would then proceed with the collection process through CSOS or through the courts, whatever the process is that we determine and decide at our cost and at our risk. And it gives the scheme funding immediately. So there is a different way out as well for schemes that have these high debtors. Get into contact with Daniela and her team, and they will be able to assist you guys with that. And thanks for joining us today, and we will keep on bringing you information that you require to run your schemes in a successful way.
Thank you. Thank you very much, Stratafin. Thank you, everyone.
Thank you so much. We'll chat to you soon, Johlene.
Bye.
Bye. Bye, everyone.
Thank
you.